Hey everyone, this is Mike DeBliss. This is part 2 of the podcast on the ABCs of Internet Law. We're going to pick up where we ended in part 1, and that is or on the topic rather, of collecting emails. So in the US, the applicable law is known as the CAN-SPAM Act, and it's CAN-SPAM. Basically, it allows you to send out unsolicited commercial emails so long as you insert in the subject line that it's an advertisement. The FTC, Federal Trade Commission, has published a good guide to comply with the Act, and you can pretty much find it on Google by just doing a Google search of FTC CAN-SPAM Act. Whenever possible, what I typically do is I encourage my clients to include a double opt-in as an extra layer of protection. I also recommend that if someone is signing up to a service, be sure to make it clear that they're also signing up to an email list so that you don't get a nasty email back when they receive a broadcast email that was part of your distribution of your email list. So let them know in advance that if they're signing up to a service, that they're also signing up to an email list, or give them the option of opting into the email list or opting out. That way you eliminate any collateral consequences later on and any nasty emails. Basically, this area of collecting emails is a murky area, and that's because the US has a very lax system, whereas other countries have stiff email laws. Some of the countries, or at least one country that comes to mind, is Canada. So it becomes difficult because people don't split their list by countries. And if they were to do that, one could imagine how time-consuming and picayune it would be. You just think about it. I mean, we're in such a global marketplace that on a list of even just 100 subscribers, you could have as many as 25 different nations represented, if not more. So to have to splice them up or separate them based on geographic location would be just completely unseemly. There are also jurisdictional issues, like, for example, how would Canada enforce their laws if you were based in France or somewhere else in the world? To keep it simple, what I recommend is to comply with the laws of the countries that you live in. That is key. So if the business is located in the United States, comply with U.S. law. If the business is located in a European country, comply with EU law. The good news is that if you're using a third-party system, like a Constant Contact, a MailChimp, any one of the traditional third-party email systems, they'll usually force you to be in compliance through their system. And if anyone has ever set up an account with MailChimp and created an opt-in, you'll know what I mean. They basically go through hoops to ensure that the person has rightfully signed up for the list, as do other email services as well. So for example, what they'll do is once the person adds their name and email address, or simply email address, in an opt-in, they'll receive an email and they'll have to click on a link to confirm that they in fact were the person that signed up and it wasn't a bot or a robot or a computer that signed them up automatically without their consent. So the main points to note here in the area of collecting emails: first, you can't have false or misleading header information. Second, the email must be sent from your real address. Third, you can't use deceptive subject lines. Fourth, if it's an unsolicited ad, it must have an ad statement in the subject line. Fifth, there must be a statement declaring your location. And as I said, a lot of the third-party email providers automatically have that built in. They won't even allow the email to go out unless the address of the business is emblazoned on the email at the bottom. And finally, you must make it easy to opt out and adhere to a strict deadline of 10 days to remove an opt-out from your list. Now, again, a lot of these third-party email providers include a link at the bottom that says unsubscribe, and that's usually the preferred method. However, every once in a while, you'll come across an unsolicited email where the sender requests has a note that says, if you wish to unsubscribe, email back unsubscribe. The problem with that is that usually it's not honored, and my experience has been that despite responding to the unsolicited email and stating emphatically that I wish to unsubscribe, I continue to get more emails from the same sender. So the best practice is to simply sign up for Constant Contact, MailChimp, Aweber, any one of a number of third-party email systems, and that's going to save you a lot of aggravation down the line. There are certain situations where you need not rather be as compliant, or where regulations are relaxed. The best practice, however, is to comply with the regulations at all times. And I'd further add to that knowing the laws in your region is critical. There is no substitute for not knowing the laws, because under the law, ignorance isn't a defense. The third-party system is best because, as I've already indicated, they enforce the regulations to a T because they have a vested interest in doing so. If they don't enforce the regulations to a T, then they don't enjoy the immunity and the protection that internet law provides them. The other issue is that they have hundreds of thousands of subscribers, so one can only imagine that it's impossible to police all of them. So that's why they have built a lot of these safeguards into their platform in an effort to ensure compliance to the fullest extent possible. Outreach emails. Unsolicited outreach emails are more likely to be viewed as a business-to-business transaction rather than a commercial email. As long as the number of emails being sent doesn't get out of hand, then you should be all right. Moving on to the trademarks. What is a trademark? Well, a trademark is a logo, a symbol, or a short phrase. We've all seen them. We've been inundated with them, with television ads, on the internet, walking through Times Square. These are, the short phrases. These are the songs, the jingles that we hear on television, in commercials, and online. Basically, a trademark identifies your brand or a product that your brand offers. They're important because they stand as a symbol to consumers of something. If you take the watchmaker Rolex as an example, if you said you had a digital watch, or you said you had a Rolex watch, the perceived value of the Rolex watch would be significantly higher because it's associated with the brand. And the brand Rolex has a reputation of being a high-end watchmaker and a very desirable watch to own. It makes a statement, not a statement as to your your socioeconomic status and other things, in the same way that a high-end luxury car does, like a Mercedes-Benz or any one of a number of high-end cars. The trademark prevents other businesses from exploiting it for financial gain by piggybacking on your brand's reputation. The critical question that comes up time and time again when it comes to trademark is a very short question, but it's one that has ripple effects for you if you are the antagonistic party in this and the defendant. The question that comes up is, quote, is it causing, meaning the trademark, confusion with consumers? If so, you're infringing on the trademark. So let's back up for a second. To form a trademark, you have to register it with the Patent and Trademark Office. You then submit the trademark and you pick a class. There's about 50 of them related to your industry. If you take Amazon.com, for example, they have that trademark. They own that trademark in the internet space. But that doesn't mean that the word Amazon can't be used with a trademark in a different industry. So for example, let's say that you are providing that you launched a company for tours on a river, and you are basically doing boat tours of the Amazon. You might look to trademark the name of your company as Amazon River Tours. Just because there is a trademark in existence for Amazon, namely Amazon.com, does not prevent you from making a pitch to the Patent and Trademark Office to trademark Amazon River Tours. Why? Because it's a separate industry altogether. Whereas with Amazon.com, it's an e-commerce marketplace. Amazon River Tours is basically a tourist company that is offering boat tours of the Amazon. So we're in two separate industries, and that's what could very well make the name Amazon River Tours kosher and legitimate and be approved by the Patent and Trademark Office. Now, it takes around 6 months for the Trademark Office to search their database for conflicts with an existing mark. When they're satisfied, they will grant the trademark. When it's granted, not only is a trademark valuable in protecting your brand, but it's also a valuable asset. For example, you can license your brand out to people. You can only get a trademark if you're using it in commerce. So there is sometimes this misunderstanding about the usage of trademark and the purpose of a trademark. It can only be used in commerce. There is an exception to that, and it's a fine line exception, and that's to file an intent to use, where you can use the trademark if you plan to release something within the next 3 months. But that's the only exception to the bright line rule that you can only get a trademark if you're using it in commerce. Occasionally, a big brand may decide to use a phrase for a campaign. This may force small mom and pop companies to change their brand names if they had not previously registered their trademark. So, one can think of, a number of big brands that have used phrases, catchy phrases in campaigns. And the problem this poses for the small mom and pop is that they might have been the one to have begun using that phrase in their campaign. However, because they had not previously registered the trademark, the big Goliath that comes along and all of a sudden starts using it and decides to get it trademarked will be able to do so if the small mom and pop hadn't registered it already. Now, there are some nuances here, and there are some defenses that the mom and pop company can potentially raise, but at the end of the day, if the small mom and pop, even though they were the originator of the phrase or the slogan, if they haven't beaten the big brand to the Patent and Trademark Office to apply for the trademark, then chances are they're going to lose this battle, and the big brand is going to be able to steal this phrase from the small business and use it as their own. Keep in mind that when it comes to trademarks, legal fees can easily cost between $500,000 and $1 million. So unless you have the cash lying around, it is critical to take out an insurance policy to cover these fees. What you can do here is purchase a basic policy with a $1 million coverage limit and then purchase a commercial umbrella policy. This umbrella policy begins to take effect after your initial $1 million has dried up. The umbrella policies, while they seem like they might be very costly, are generally inexpensive because they're rarely used. Let's talk about the future of internet regulation. Governments are beginning to catch up with the internet age, although some of them are still stuck in prehistoric times. And the internet is no longer the Wild West that it used to be. Governments have enacted strict laws and have begun to establish their jurisdiction in the online space. Now, with so many countries introducing a myriad of laws, what's bound to happen and what has happened is that many countries' laws are in conflict with each other. This presents challenges because, as is so obvious, the internet is a global marketplace, and most websites have customers from all four corners of the world. For example, if you take a look at China, it has recently introduced a law making anonymity illegal on the internet. And if you look at a country like Russia, they require companies to store their servers in Russia if they want to collect Russian citizens' information. If you don't agree, then Russia may ban your site. So as you can see, these countries have enacted laws that are very protectionist in nature and that very well may conflict with the laws that have been passed by other countries. And so this fact that we have contradicting laws is problematic, and the fact that the internet is a global marketplace. So for businesses that are targeting the U.S. marketplace, this is like a quick and dirty example. For businesses that are targeting the U.S. marketplace and do little business in the EU, a genuine question arises as to whether they should block all traffic from the EU and stop it from coming to their site. Why? For the simple reason that the cost of compliance with the EU is staggeringly more than what they stand to earn in business from EU customers. So what these companies are forced to do is a balancing test, and they're forced to basically look at their customer lists, look at the people that are purchasing their products or services online, and determine geographically where they're based. And then once they create a spreadsheet and they know where their customers are coming from, determine what the regulations and laws are for being in compliance with internet law in each of the countries where they have customers. If they find, for example, that in the EU they only have maybe 100 customers and the cost of compliance in the EU is staggeringly high, they might make a business decision to stop or halt doing business in the EU altogether. And how would they do that? Well, as I said, they would block all traffic from the EU and stop it from coming to their site. And again, this is done to protect them in the event that later on down the line an EU regulatory body brings a claim against them for not being in compliance with EU internet rules or regulations. So this is a balancing test, and it's a business decision. And again, it comes down to dollars and cents. Other factors that would go into this decision is that even if there are only 100 customers in the EU, is the company poised to grow in the EU? And do the founders of the company believe that the growth is going to be exponential over the next couple of years to justify the additional expenditure of compliance in the in the immediate present? So these are all factors that have to be decided on when deciding whether to continue business with these customers in this region of the world. And I say this because, as you probably got the drift, compliance with EU laws is painstakingly tedious. And the cost of compliance, not to mention the risks of non-compliance, are greater than the money being generated in these regions most of the time. With all the different laws being introduced, it's possible that the day may come when digital continents unite, where business owners strategically decide not to make their websites available in certain regions of the world because of overregulation. Let's talk about international enforcement. The issue here for law enforcement is how to enforce overlapping laws. It's not easy. My experience in this space has been in the area of international tax and international tax compliance. And I'll give you a quick and dirty example. The overlapping of laws in the international tax arena has simply wreaked havoc and has spawned an area of law in the United States known as U.S. international tax law. It is extremely tedious and complicated to understand because different countries have different taxing systems. For example, the United States taxes its citizens and residents on their worldwide income. Other countries tax based on a territorial regime where they only tax residents' income that's generated within the borders of the country. So what that presents is an issue, worldwide taxation, that is, presents an issue of double taxation, where a U.S. citizen who has moved to the EU could be running a business that's generating a significant amount of revenue in the European country. Well, even though that income is generated offshore and is generated in France, for example, the United States taxes that income as if it was earned in the United States. And the relief that the United States provides to the business owner that's living abroad is that it entitles the business owner to a credit that offsets the amount of tax that they would otherwise owe the U.S. government. So for example, if the owner is in a 35% income tax bracket in the United States and a 25% income tax bracket in France, they would essentially pay 25% to the French taxing authority, and they would pay the difference between 25% and 35%, which is what their income tax bracket is in the United States, to the U.S. taxing authority. And that tends to mitigate the harsh impact of worldwide taxation. There are also tax treaties that are in place, and over the course of the next couple of years, I foresee that there will be treaties that emerge between the United States and other foreign countries in the internet space as well. So getting back to this issue of international enforcement in the internet space and how there's going to be policing of these overlapping laws, it's easy to hold large companies like Amazon accountable because they have a presence in places like the EU. But say, for example, you're running a $2,000 a month affiliate site from your apartment in Chicago, Miami, or San Diego. The question here is, how do they actually penalize you? And so there's going to be a lot of brainstorming on this, and there's going to be a lot of strategizing between and among countries to come up with treaties that both are favorable to the country and that at the same time, are whet the appetite of the country that the U.S. intends to enter the treaty with. Otherwise, there's no incentive for that country to enter into the treaty. So let's talk about some key takeaways from episode 1 and episode 2 of the ABCs of Internet Law. First, force your users to accept your terms of service using a checkbox and keep server logs. Second, when you update terms and conditions, remember that you want your users to accept them before they can continue using your site. And a prime example was the one I gave in the episode 1 about Airbnb and how they're constantly updating their terms and conditions, no different than Instagram, no different than Facebook. They basically say that the user, they send out an email to all of their users, and they basically say that they basically list what their updated terms and conditions are, and there's a button at the bottom of the email that the user has to accept those terms and conditions. If the user doesn't have to accept those terms and conditions, but if they don't, then they can't continue using the service. So it is one-sided in that sense. However, there's no rule or law that prohibits the company from doing this. And in that sense, it's very adhesive. It's very favorable to the company. So long as they send out that broadcast email, they've done and they've provided the users with the with the updated terms and conditions. There's no recourse against the company on behalf of a user. If they don't like the updated terms and conditions. Can you imagine what that would be like if Tom, Dick, or Harry were to respond to one of those broadcast emails by saying, I don't like updated condition number 3, so I'm going to modify it to be consistent, or to be consistent with what I think it should be. And then you would have everybody doing that, and the slippery slope that would create would be just exponential in magnitude. So that's why it is very one-sided, and that's why the user basically has no right to sue the company, or no cause of action to dispute the terms and conditions. They are what they are. You either accept them or you don't. If you don't, you can't use the site. Use disclaimers. Number 3, use disclaimers on your pages when giving advice, such as health or financial advice that can affect people's lives. 4th, clearly display an earnings disclosure on your site if you're making affiliate income. 5th, linking to the original source of an image does not cloak you in a veil of immunity when it comes to copyright liability. Simply don't take photos. Basically, what you want to do here is use stock photos. Sign up for a stock photo site that enables you to use any one of a number of photos in the gallery. That way you're always safe and protected. 6th, use a third-party email platform like a MailChimp or a Constant Contact, as they force you to comply with spam laws. As a matter of fact, these days, a subscription to, I believe, MailChimp is free if your list is less than 1,000 subscribers. I think that's what it was at last the last time I viewed it. So the price is right, and you know you're going to be in full compliance because the company is basically built it into their platform, and that's the way they enjoy the immunity from claims that could arise later on by being in steadfast compliance with the spam laws. Seventh, register your brand as a trademark or risk losing it to someone else. And finally, you can never go wrong when it comes to purchasing insurance. I realize that that's oftentimes the last thing on your mind with the startup costs, with the creation of the website, with hiring a developer, with hiring a creative person to do all of your visuals and all of your images, and not to mention the fact of having having an ISP and then having a company like GoDaddy hosting you. All of these costs add up, and when you're launching a startup, you can't predict the future. You don't know whether it's going to succeed or not. So the last thing on your mind is liability from lawsuits later on. However, just as important as it is to consider incorporating the website name and copywriting it and protecting it so nobody can take it from you, it's important to purchase insurance. And again, I know this is the last thing on people's minds, but it should actually be moved up to one of the first things on the list of priorities. Be sure to purchase liability, trademark, and a further umbrella insurance policy. And you will certainly be thankful later on down the line if you find yourself being hauled into court for a matter that arises out of the use of your website. You don't want to be stuck where you're kicking yourself for not doing something that could have easily been done when you first incorporated the company. So I would make a general point of buying the insurance at the time that the website is going online and at the time you've incorporated it, and don't hold anything to chance. If you have any further questions, feel free to email me and anytime. My email address is mjdeblis@deblisslaw.com. My door is always open.